In terms of no proper foundation or authentication, of course, first it's rule of evidence, 901B5, opinion about a voice. An opinion identifying a person's voice, whether heard firsthand or through mechanical or electronic transmission or recording, based on hearing the voice at any other time under circumstances that would connect it with the alleged speaker. So that's really the standard. There is a case. Let's see, this is another memorandum opinion by the Supreme Court. Of course, I know it's not binding perhaps, but it's instructive. It's State versus Spalding, 2015 Westlaw 3875802, sub-opinion number 14-0718. And it cites Rule 901 concerning authentication, but it says preliminary questions of authentication and identification pursuant to Rule 901 are treated as matters of additional relevance and thus are governed by the procedure set forth in West Virginia Rule Criminal or Evidence 104B. In an analysis under West Virginia Rule of Evidence 901, a trial judge must find that the party offering the evidence has made a prima facie showing that there is sufficient evidence to support a finding that the matter in question is what it opponent's claim. In other words, the trial judge is required only to find that a reasonable juror could find in favor of authenticity or identification before the evidence is admitted. The trier of fact, or the jury in this case, determines whether the evidence is credible. Further, a trial judge's ruling on authenticity will not be disturbed on appeal unless there has been an abuse of discretion. So ultimately, it is the jury to decide whether the voice was that of the defendant, and the court would conclude that based upon their verdict that they did so far. So the court believes that it has been properly authenticated and identified. In terms of the ground as a continuance due to a lack of disclosure of evidence, again, there's no evidence or allegation of prejudice. It's speculative, irrelevant at this point. In other words, I think you have to be specific in terms of this evidence was not presented, and this is how it was prejudiced. And so those issues can be brought up under Rule 35 or under writ of habeas corpus if you get that far. In terms of the jury instructional error, this is a statutory offense. The instruction followed the statute with added language that the defendant wanted. And I mean, I know he made some wholesale objections to the charge. Sort of rule all those. But in terms of the actual jury instruction on the elements, I'm not aware, maybe he did, and you can pursue that on appeal, but I'm not aware of any objection being made to that instruction, the actual elements instruction. But he did want some clarification, and so the court added a sentence or two or three that was given to the jury. And I was not aware of any other request or anything else. And so I can't rule on something that wasn't brought to the court's attention, but I can't. Either way, I think that everything was dealt with and that the instruction was proper. So, based upon that, then the court would deny the defendant's motion for judgment of acquittal or for a new trial. Mr. Deegan, do you have any evidence you wish to present on the issue of sentencing?
Just statements.
Okay, May?
Do I get a rebuttal after the state goes?
Well, we'll see. I don't know that it's required, but I may very well give you the chance.
Okay. I will stand by my statements over and over again that I never conveyed a threat of any kind or nature to any man or woman, period. There's never been a threat I've ever made in my entire life, let alone at this time being accused. I'm innocent of those charges. I did grow a plant. That is true. For that offense, I was serving time, and I had served it dutifully without any problems of any nature or kind. I've been confined now for close to 22 months roughly, with no problems of any nature or kind. I live in North Central for on home confinement. I was actually at the 14th month mark when picked up by the state police and was actually eligible for parole and had put in for parole approximately 2 months before that on that first charge. I now have 7 months in on this second charge. I looked at the pre-sentence investigation report. It appears that the index numbers stayed the same, which means that I'm no more a threat than I was last time. I would say I should be allowed to finish the original sentence pursuant to the contractual agreement with the state and roll off it to the new charge. It appeared that in the pre-sentence investigation report that alternative sentencing was available. I would ask for home confinement or probation on that. I would like to see him served concurrently. But I feel that as I'm not a threat, and the evidence, the property seized from my home, they tore the home apart, did not find any weapon of any kind. They accused me of any kind of being dangerous, and yet have actually been unable to prove that I'm dangerous to society at large. I've been in the regional for close to 12 months now, and I've watched people that actually murder people, harm people, molest children, get out and go home. I've watched people commit violation after violation of home confinement and probation and go back home. I am less of a threat than any of them. The index, if it can be trusted, shows I'm not really a threat to anyone. The state's going to argue I'm this big monster. They have not proven that I'm a monster anyway, and the fact that they used and had zero evidence from my home to prove that I was a danger solidifies that. We had Steve Stevens, the head of home confinement, say I was a model client, never had any problems with me, and that he would take me back. With that, I would just restate and incorporate herein all of my arguments and or papers that I've written as part of the public record creation live.
In February of 2010, Thomas Deegan was arrested for growing not a plant, but 63 live marijuana plants. In March of 2010, the defendant was placed on bond. A hearing was set in February 2012, and the defendant didn't show. He absconded. There was a habeas issue. The defendant did turn himself in. It wasn't until July of 2014 that the defendant was found by a deputy and he was arrested. The defendant was sentenced in that case to 1 to 5 years to be served on home confinement. We did hear that the defendant didn't test positive for drugs while on confinement and that he followed most of the rules while on home confinement. However, he did something much worse while on home confinement for his previous conviction. He plotted and made threats to take over the West Virginia state government. We heard the evidence of what he did while he was on home confinement. And I know the court listened to all that evidence, so I won't go over all of it at length, but we heard a conference call with a large number of people. And I believe that it was stated in that call that there was a guy on the call that had, I believe, 60-some people just muted. So there were a large number of people on this call where Thomas Deegan was leading this conversation, where he told them that the soil has to be controlled. It starts with West Virginia. He told them to Google Earth Charleston, West Virginia, to Google Earth the National Guard, the West Virginia State Police, and the Kanawha County Sheriff's Department. He wanted them to know where these people were, and he told the military people that were on the call, you know how to deal with these forces. And I think the most chilling of the statements and the directives that this defendant gave while on this conversation call, when asked what to do if police arrived, he stated, the police are your enemy, and if you see the police coming and pulling in a vehicle, I suggest you shoot them. He had every intention of this being put. The defendant made these threats on this conference call, and he did more than that. He actually planned and plotted and asked these people from all over the country, and we heard that there were some people who were planning to come. From Arizona, from California, from Florida, from Texas, all over the country. And this was while he was on home confinement. These people were coming. After we heard the conference call, we heard video. It was taken approximately a week later, where he was interviewed by a guy out of Canada. He didn't back off his plans to take over the West Virginia state government. The only thing he said is it wasn't going to go forward at this time because there were federal operatives on the phone call. And he was being watched, and he wouldn't be able to do it directly himself, but he would love to support somebody else who wants to do it. He planned on this going across the United States, but it started with West Virginia. And we even heard that he planned on going to Charleston and violating his home confinement because home confinement wouldn't mean anything at that point. We then heard a phone call that he made while he was incarcerated. He knew he was guilty. He knew what he did was against the law. And he stated that. He was guilty under the statute. The defendant hasn't shown, and one of the most concerning points in the sentencing, I think, for the court to consider this, the defendant hasn't shown any remorse whatsoever. He doesn't see anything wrong with getting on a call and telling these, at least 10, a number of people, to come to Charleston, West Virginia, bring arms, and take over the state government, kick people out of the Capitol, shoot police. He sees nothing wrong with that. The defendant hasn't taken responsibility for his comments, but he hasn't denied them either. I've heard that he argues that he should be able to say whatever he wants to say. He hasn't taken responsibility, he hasn't denied it, but he absolutely has shown no remorse. He sees nothing wrong with what he did. I think it's also telling, Your Honor, to look at the conduct that this defendant has shown in your court. He kept saying he didn't understand. He kept giving the court issues. Some of them were valid, some of them he had issues and questions of the law. That's fine. But then we heard on phone conversations in the jail that he knew he was guilty, but he was still going to give the court a hard time. He wanted to make a mockery of his court. He wanted to slow down the process and waste the court's time. All these things that the defendant did, even though we did hear that he didn't violate all the rules of home confinement, that he didn't test positive for drugs while on home confinement, but these things that he did, plotting and threatening to take over the West Virginia state government, that was while he was on home